Today, the Chief Justice handed down an important ruling in one of the cases filed by Mr. Azruddin Mohammed in the High Court challenging the extradition process. Now, as a matter of background information, your viewers would recall that Mr. Mohammed and his father filed two sets of legal challenges in the High Court, and both are being heard by the Honorable Chief Justice. In one set of proceedings, they challenge the constitutionality of certain provisions of the Fugitive Offenders Act, more specifically, the amendments which were done to that act in the year 2009. Secondly, they have filed a second legal challenge in the High Court in which they are challenging the authority to proceed issued by the Minister of Home Affairs, as well as every other act or actions that would have flowed from that authority to proceed, including an arrest warrant under which the fugitive offenders were arrested, and consequently the proceedings that are ongoing at the Georgetown Magistrate Court before Learned Magistrate Judy Latchman. In that second proceedings, they are contending that the minister is biased, the government of Guyana is biased, the president is biased, the attorney general is biased, the vice president is biased, and the entire government architecture is biased because Mr. Azruddin Mohammed is a political competitor to the government and was a political competitor to the government at the recently held elections, and therefore, as a result of that bias, the authority to proceed is defective and everything that flowed therefrom is defective. And they want the authority to proceed to be quashed, and they want all consequential steps taken thereafter to also be quashed. So the Chief Justice heard arguments from all sides. Your viewers would know that we attended court. They sued the Minister of Home Affairs in that proceedings. They sued the Attorney General. They sued the Learned Magistrate. Mr. Douglas Mendez, Senior Counsel, appeared for the Learned Magistrate. I appeared in person for the Attorney General, and the Learned Magistrate was represented by independent counsel. The Learned Magistrate played no part in the proceedings, but of course, the lawyer for the Minister and the Attorney General participated along with their lawyers. And we put out our arguments. We say the question of bias does not arise, that in any event, the Mohammeds entered politics long after the extradition process would have been activated, long after they were afflicted with OFAC sanctions, and they choose to go into politics after these events, and therefore to erect a defense of politicization and political bias is simply manufactured, and that is not the law. That the question of bias and those persons who are the tribunals that are to be independent are the judicial tribunals that are all part of the extradition process. That the question doesn't arise, the question of a bias action doesn't arise in relation to the executive. That the executive has the constitutional functions to perform in relation to the extradition process, and that the executive, the government of Guyana, has the legal and treaty obligations to discharge their duties under the law and under the treaty in relation to bias. If that is a defense, then every person who is the subject of an extradition request can then enter politics if he knows it is coming, or enter politics after, and use that as a basis not to be extradited. That cannot be the law of Guyana, and that is not the law of Guyana or the law of any other country. And we also obviously found case law authorities from across the Caribbean and the Commonwealth and England to justify our position, because these matters have been litigated in different courts across the world, and there is great judicial guidance in high courts and appeal courts all across the globe. We cited those cases, and the judge, after hearing all the arguments, fixed the 2nd of February to rule in that matter. On the 2nd of February, the judge did not rule because apparently he did not complete the writing of his judgment. At the time they had filed this action, they had also filed a stay of proceedings, of the magistrate's court proceedings. Let me rephrase that. At the time they filed this action, they made an application to the judge to stay the magistrate court proceedings while this action was going to be heard and determined. We decided as a collective that because the magistrate court was adjourned until the 5th and 6th of February, and this action was being heard in January, that the action can possibly be concluded without a stay being heard and determined. And on that basis, the judge proceeded to hear the proceeding itself rather than the application for a stay. But after the judge was unable to decide the case on the 2nd of February, as he had indicated, the lawyers for Mr. Mohamed wrote the judge, I think the 2nd was Monday, wrote the judge, I believe, after receiving the notification that the ruling was going to be adjourned to the 9th of February. They wrote, I believe, Monday itself on the 2nd, to say that they would like their stay application to be heard, not orally, but on paper, because they had already have the application there. And myself and Mr. Mendez, on behalf of the Minister of Home Affairs, wrote objecting to the stay and said, and we put out our arguments why a stay should not be granted. It's against that backdrop that the judge brought back his ruling from the 9th of February, which was supposed to have been delivered on the 9th of February, and delivered it today. Rather than deal with the stay, he decided, I suppose, that he will deal with the entirety of the case one time. So there is no need for a stay. And he delivered that ruling this afternoon, and we all received it by email. And in that ruling, he dismissed the action or the proceedings filed by the Mohammed in which they are claiming the bias. He adopted our submissions. He relied upon the authorities, the judicial authorities that we produced, and he ruled that a case for bias has not been made out and cannot be made out, that the minister is not performing the type of function when she is issuing that authority. She's not performing a judicial or a quasi-judicial function, but is simply discharging an executive function and a statutory diktat which Parliament has invested her with by virtue of the Fugitive Offenders Act, and that the question of bias does not arise. That the question of bias, if an allegation of bias can be made, can only be directed to the judicial tribunals. That is to say, the magistrates court, the high court, and if they go to the court of appeal and elsewhere. That in extradition proceedings, the question of bias does not apply to, and principles of bias do not apply to a magistrate, the Minister of Home Affairs, when that minister is exercising the power to issue or not to issue the authority to proceed. So in short, This case filed by the Mohammeds have been dismissed, and each party has been awarded $500,000 in cost. That is to say, the Attorney General 500,000, the Minister of Home Affairs 500,000, and the learned magistrate Judy Latchman 500,000 in costs each. So that has brought the end of this set of legal proceedings in the High Court filed by Mr. Mohammed. There is another set, as I said at the commencement of this interview. That is the one in which they are challenging the constitutionality of provisions of the Fugitive Offenders Act. That proceeding is still pending, and those proceedings are scheduled for ruling, I believe, on the 16th of February. Um, all arguments have also been heard by the judge from all sides, and written submissions made by all sides, and that is scheduled for ruling. And that will dispose of their second proceedings in the High Court, whichever way the court rules. Just as an update, the magistrate court proceedings are expected to continue tomorrow and Friday, and we will see how it unfolds from there. So that's the update I would like to provide. Thank you very much.